Welcome. Today, we are going to demystify trademark law. And don't worry, we're skipping all the dense legal jargon. Instead, we're breaking down 7 huge court cases into a powerful, practical guide that'll help you protect your brand. So let's dive right in.
So let's just start with the big one. It's a question that honestly every single founder should be asking themselves. You pour your heart, your soul, everything into your business, your brand, your name. But what if that name, the one you love, actually puts a legal target on your back? That's exactly what we're going to explore.
Now, these aren't just rules you'd find in some dusty old textbook. Nope. These are lessons forged in the fire of some really high-stakes lawsuits. We're looking at real companies, real mistakes, and of course, some very real consequences, all to uncover the kind of practical knowledge you need to build a brand that's built to last.
All right, so our first lesson is probably the most fundamental of all. Originality is your best defense, legally speaking. You know, it can be super tempting to borrow a little something from a successful brand, but as we're about to see from a couple of very different examples, that is a trap that can cost you, well, everything.
Let's kick things off with a classic. So a coffee chain in India pops up called Sardar Baksh. Now just take a look at their logo next to Starbucks. The similarity, I mean, it's pretty undeniable, right? Starbucks, which is a registered trademark in India, obviously sued. And the result? Well, Sardar Baksh had to change both its logo and its name. And you know what? It's not just about logos. In another case, an Indian company started selling products that were just blatant copies of the American appliance giant, Whirlpool. Now, they might have thought they were safe, operating in a totally different market, but they were wrong. Whirlpool sued, and they won.
And winning didn't just mean, hey, stop selling that. We're talking about a serious penalty. The Indian company was ordered to pay somewhere between 30 and 40 lakh rupees. The key takeaway here is so important. Copying an established brand, even one from another country, isn't just a bad look. It is incredibly expensive.
Okay, on to our next lesson. This one is all about the name you choose right at the very beginning. See, not all names are created equal, and as we're about to find out, picking a common or descriptive word for your brand can put you on some seriously shaky legal ground. This brings us to this idea of a generic mark. Basically, it's a common word for a whole category of stuff. For example, a fruit company couldn't just trademark the word apple and stop all other farmers from using it. That would be ridiculous. But Apple, the tech company, they could. And that distinction is absolutely crucial. So let's see how this exact thing played out in the tech world. You have the payment company PhonePe, and they sued a competitor, BharatPe. Their argument was that the suffix pay, that's PE, was a core part of their brand and customers would get confused. But the court's response to this? Oh, it was brilliant. They basically ruled that P is just a common misspelling of the super generic word pay. You can't own a common action just by changing one letter. So PhonePe lost, all because their name was just too generic to defend. This really highlights a key trade-off you have to think about. Compare a name like PhonePe to a brand like Zara. Zara is a totally invented word. It has no prior meaning. So yeah, it's a bit harder to build recognition at first, but once you do, your trademark is like a fortress. It's so strong. In fact, when another company tried to launch something called Zara Fashions, the original Zara won that case easily. All right, let's see how all this stuff applies in the digital age. Because let's face it, brand protection isn't just about logos and storefronts anymore, it's about your digital real estate. And this brings us to something called cybersquatting, which is basically just registering domain names of famous brands to try and profit from them. One of the first big cases of this in India actually involved Yahoo. Back when the company was a global giant, some guy registered yahooindia.com hoping to cash in on the name recognition. Well, the court shut that down really fast, and it set a clear precedent. You just can't register a famous trademark as a domain name in bad faith. But that was a pretty simple case. Today, things are way more complex. What happens when someone uses a platform like GoDaddy to buy a misleading domain name, and then they use it to commit fraud? Is the platform, GoDaddy, responsible? Or is it just the person who bought the domain? So this exact question came up when the Academy Awards sued GoDaddy. The court decided that a platform like GoDaddy is just an automated broker. It's a tool. It's not a publisher that's supposed to be vetting content. So if a user buys a domain like amuldistributor.com to scam people, the liability, the responsibility, is with that user, not the platform that sold them the domain name.
Okay, for our final lesson, we're moving from public battles in courtrooms to private agreements between partners. Because, sometimes the biggest threat to your brand isn't a competitor at all. It's a partner. especially when your contract just isn't specific enough.
Let's look at the case of Coca-Cola and Bisleri. Bisleri licensed its water brand to Coca-Cola for use in India. Sounds simple and straightforward, right? Well, the problem wasn't what the contract said, it was what it didn't say.
The agreement gave Coca-Cola rights inside India, sure, but it didn't explicitly stop Bisleri from using its own trademark in other countries, like Turkey. It also didn't say anything about online versus offline rights, or other really crucial details. All this ambiguity, this gray area, led directly to a massive legal dispute.
And that right there is the ultimate lesson. Every single right, every limitation, every territory has to be spelled out in detail in that contract. Because if you leave anything open to interpretation, you are basically leaving it open to a lawsuit.
So let's bring this all home. Let's boil it all down. Here is your 4-point brand protection blueprint based on these landmark cases. Number 1, avoid copying. Originality is always your best defense. 2, choose wisely. An invented name is way stronger than a generic one. 3, defend your domain online, but know where the liability really is. And finally, number 4, detail your deals. Put everything in writing.
Look, at the end of the day, your brand is the title of your story. And what these cases show us is that protecting that title isn't just some boring legal formality, it is essential business strategy. So the real question you have to ask yourself is, have you done enough to protect yours?